Honourable, thank you very much. It's always a pleasure to see you in the chair, and I beg to move that the House has considered the use of unpaid work trials at the outset of employment. Now, honourable members present will know of my long-standing interest in the issue, having introduced the Private Members Bill after the 2017 election, the Unpaid Work Trials Prohibitions Bill, which unfortunately, I hate to start on a sour note, was talked out by the Minister's predecessor when he was in his role. But I am an optimist, and I am optimistic that this new Minister will drive us in a different direction, see the gravity of the problem, and bring forward the necessary legislation to prevent this exploitation continuing. Mr Chairman, in the preparations both for that bill, for today's debate, and in the long campaigning that has been done on the issue, there are many people I should thank for their input, not just in this House, but outside of the House as well. There is one campaign I'd like to single out for mention, if you would permit me, Mr Hollowborn, and that is Unite's Better Than Zero campaign, who have been at the forefront of challenging not only the use of unpaid work trials, but actually in putting forward a credible alternative to exploitative work practices that happen, particularly their focus on the hospitality sector. And I would encourage all honourable members to support their campaign and in particular their hospitality charter. Mr Hollowborn, if I could be permitted, I'd like to outline exactly what it is that's going on and why it is a problem that needs fixing. An unpaid work trial, the period between applying for a job and being given the formal offer of a job, is at the heart of what it is I want the government to fix. I want the government to fix the fact that this part of employment law, although I'm sure the Minister is going to dispute this when she gets to her feet, is entirely unregulated. It is a deficiency in the Minimum Wage Act, which, in fairness, I don't blame Labour for. Nobody saw this as an issue and hasn't seen it really as an issue for the last 20 years, but it's a deficiency in the law that needs to be fixed. In my research for this and in the preparations for my private members' bill, many hundreds of people have been in touch with me to give me their own personal experiences of what it's like to take part in an unpaid trial shift. I've done it myself when I was younger. I'm sure many other honourable members have too. They go from, on the one hand, Mr Chairman, perhaps a couple of hours, maybe in a coffee shop or a hotel or whatever, right up to the extreme end, the most extreme that I had come across being a 40-hour working week, where you tried out for a job that you weren't paid for and didn't have a guarantee of getting the job at the end of it. Perhaps even, I'd certainly give way.
Thank you. I thank the honourable gentleman for giving way, and I want to congratulate him on all the work that he's done to bring this issue, this important issue, to the public's attention. Does he agree with me that, given the scale of this abuse of workers, that over half of people either knew or had known someone or had themselves experienced an unpaid work trial, it shows the scale of this problem and the abuse that's taking place?
Well, indeed, although there are no government statistics or trade union statistics on this, Mr Chairman, it's a problem that everyone knows exists because we've either done it ourselves or we know somebody who has done it themselves. So not only do we have a situation where there are people working for, as I mentioned, in one case up to 40 hours trying out for a job with no pay, Mr Hollowborn, but we actually have the vicious situation of people being offered work trials for jobs that don't even exist. And that can take the form, Mr Hollowborn, of a job being advertised, perhaps for a business to get itself through a busy period, say Christmas, or if it's a hotel, maybe wedding season in the springtime, or indeed it can be used to cover staff sicknesses, where people are being taken advantage of, being asked to come in and try out for jobs that there is absolutely no chance of them getting because all the employer wants to do is cover shortages in their own rota. I'd give way.
I thank the honourable member for giving way and congratulate him on securing this debate. He talks about some of the more extreme examples. Would he be shocked to hear that he experienced one of my constituents who had a 7-day unpaid work trial, but was also told that if she was subsequently employed, she would have to repay, if she left within the first year of employment, she would have to repay the company for the cost of her training and for her DBS check.
I'm blown away for words, rather unusually, Mr Holloway. I had never heard of that kind of thing happening before, but I have to say it doesn't at all surprise me. And can you imagine how dispiriting and depressing that would leave an applicant feeling, having to go through that kind of situation, particularly if you are an applicant who has been applying for job after job, often getting nowhere, not even getting any feedback from those that you are applying to in the hope of securing employment? Certainly.
Thank the Honourable for giving way. And clearly he outlined some concerning issues, and I don't think anybody in the debate today would be supportive of somebody not being paid for a one-week work trial, if that is how it's badged. But there are also legitimate concerns that, and I wonder how he would deal with this, that people, as part of the interview process, may be asked to perform certain work tasks to see whether they're suitable to be employed in that job, and how he would differentiate between the unethical practices he's just outlined and between genuine job interview and job selection processes.
Well, the bill actually deals with the very scenarios he is posing, Mr Hollowbone, because I'm not against trying people out for a job. Let me make that clear, and the bill is quite clear on that as well. What I am against is the use of trials, unpaid trials, to exploit people. Now, I'm actually going to come to a business that's changed its practice as a result of this debate coming up that will perhaps speak to his concern. But the reason I can do that, Mr Chairman, is because there are employers indulging in this practice who know it's wrong. And I know that they know it's wrong because they've changed their practice after the bill coming forward last year. I'm going to give two examples. The first one, believe it or not, Mr Hollowbone, is the BBC. The BBC, I had been told, were taking advantage of young freelancers, often young freelancers, abusing their time and their talent and their energy, involving them in the production of programmes, and doing that through the guise of an unpaid trial period. As a result of me writing to the BBC about this, they've now stopped that very practice. Why? Because they know that it's an exploitation. Aldi, for example, have changed the way that they interview and recruit people. Aldi have taken away the element of what they previously thought was the interview, whereby someone was carrying out the work task, and they've taken the work task away. Instead, what now happens is they have a shorter interview period that involves shadowing someone around the store to see exactly how the business works, and crucially, so the applicant to determine whether or not the job is for them. And that is a better way at recruiting people. What my bill also did, Mr Hollowbone, was give some of the cards, actually, to the applicant, because it strikes me that the applicant holds very few cards in this entire process. So my bill made it clear that employers were offering a trial shift. It had to be for an actual job that existed, that the trial period was stipulated in black and white when it started, when it finished, and also that it made clear to the applicant that however it was they got on during the trial, that the employer would give them proper feedback as to whether or not they had got the job itself. My bill, Mr Chairman, was all about empowering applicants and making it clear to them that the law is on their side, rather than having a deficient law that too often is working against them. Now, Mr Chairman, when I brought this forward, the government were of the view that the law was not deficient, that the law actually deals with this as it is. And in fairness to the new minister, she has brought forward guidelines on the use of unpaid work trials. Now, that's welcome. I get that change often happens in small steps, Mr Chairman. But I'm afraid that it's not enough. And the Minister, I'm sure, is unsurprised to hear me say that. We know that there are millions of people up and down the UK crying out for proper legislative change that backs them when they're trying to go for a job. At the minute, it absolutely does not. That can be evidenced by the fact that there has never been a single fine. Sure.
has been called in the House. The sitting is suspended until 4:55. Order, order.
Mr Holloway, you'll be glad to know I'm bringing my remarks to a close to allow the debate to properly begin. But I was just stating that it is my understanding of the government position that they believe the current law is sufficient, presumably with the addition of their recently published guidelines. But evidence to the contrary suggests that it is not. And that evidence, Mr Chairman, is the fact that not one fine or prosecution or even a public shaming of a company or employer that has used unpaid trial shifts, particularly in the most pernicious and exploitative fashion, have ever taken place in the entire history of the National Minimum Wage Act. Now, I'm sure many members will wish to share experiences that their constituents have shared with them, Mr Holloway, so if I could be permitted, I'd like to share just one. And this came from a mother whose son had gone through an unpaid work trial. She said, "My son was asked to do a trial shift in our local restaurant. The manager who was on shift did not even speak to him when he was in. He was left in the bar with no direction, and when he tried to help others, he was told to get back behind the bar. He wasn't paid a penny for his time. The same restaurant had already done the same thing to a friend of mine's son, except it was for a kitchen porter. He did 4 hours, no pay, and again at the end of the shift, he was left waiting over a week with no job offered." Now, I can't expect the government to legislate against obnoxious behaviour, as surely that example represents. But they can legislate, Mr Chairman, to prevent unpaid trial shifts being used in such an obnoxious fashion. And if I might just be slightly, well, some might say partisan, I happen to think it's an accurate observation. This is a government utterly out of ideas, Mr Chairman. I'm offering it a free idea. I'm offering it a free idea at a time when we're asked to believe that the Prime Minister wants to improve and enhance workers' rights in one fashion or another. So if it doesn't do it in this parliamentary session, assuming there is no general election between now and an upcoming Queen's speech in June of this year, can I plead with the Minister, plead with her to do everything she can to make sure legislation is brought forward in one form or another, either in this session or in the Queen's speech later this year, to ensure that we can end the use of unpaid work trials. Mr Chairman, when I was lucky enough to be called in the ballot for private members' bills, inevitably you get bombarded from outside interests about what they'd like you to bring in a bill to achieve, and obviously any member who finds themselves in that position wants to bring in a bill that can genuinely make a difference to people's lives. There are millions of people, particularly young people, up and down this country who have fallen victim to this practice day after day for many, many years. Even with the new guidelines, millions more will fall victim to it. Knowing what we know, it would be an utter dereliction of duty for this Parliament and this Government not to